This show does not constitute legal advice and is for educational purposes only. We are always available to field questions. However, until you have entered into a written agreement, your communications are not confidential and we are not acting on your behalf.
Hi, I'm Sarah Holland. Welcome back to Man vs. Land. Today we have attorney Mark Lamper with us to talk all sorts of wills and estates and other legal mumbo jumbo. So welcome, Mark. Thanks for coming back.
Thanks for having me here.
You've been here a couple of times.
I have been. It was the very first episode of Man vs. Land, which I watched last night. So
yeah,
it was a lifetime ago. You've been doing this for almost 8 years.
Well, we just rebooted it, so we're happy to have you back for this new life of Man vs. Land.
Glad to be here.
All right, so we had a little chat before we started filming about kind of these topics that consumers really need to be paying attention to, that they may not have top of mind, and sometimes it's too late when they do think about it.
Right.
And one of those things is estate planning. Do you want to chat a little bit about what that means, and then we can kind of go into depth from there?
Right. So estate planning is different from financial planning. That's where you've got an investment counselor and for 401k, stocks, bonds. Estate planning can kind of go hand in hand with that because you want to, there's basically 4 big things that you want. When you pass, you want to give what you want, when you want, how you want, to who you want. So that is your estate plan. Generally, there are 2 testamentary instruments. These are things that you use when you die. There's the will, simple will that people have had throughout generations, and then I say more recent, with the advent of the Uniform Trust Act, you have a revocable trust. And so when you have a revocable trust, you've created something else that's going to live and breathe after you stop living and breathing. But they're both testamentary instruments that let you do those big 4, leave what you want, how, etc., to who you want. So.
And what does testamentary mean?
It means when you die. It comes into play to pass assets to another individual. The big difference between a revocable trust and a will is that the purpose of a revocable trust is to avoid probate. So again, this entity will keep living after you've passed. You've named a successor trustee to act in your stead when you're unable to or you've passed. And then they will follow the rules in the trust to liquidate assets, distribute assets, hold assets, and distribute your estate that way. A will accomplish the exact same thing. However, there's a greater delay and cost with a will because you will have to probate a will. Probate process could be its own talk. But long and the short of it is you have your will and you submit that to the probate court, which is now not county-based, it's circuit court-based. And so the probate court will basically bless the wishes in the will. There's a lot of steps. You have to file the petition for estate administration. You have to do an inventory to say, real easy, all your stuff. Mm-hmm. Yeah, I had a car, I had a bank account, I had a house. And then you have an accounting, which takes into consideration all those assets right now. Has anything appreciated since you had passed? Did you sell a house? And did you make a profit from the house? And that's called an accounting. Once you churn all that through, then the court will hopefully bless the situation, and then you can finish passing assets, bank accounts, cars, real estate. The big issue with the wills, I think, at this point is that the probate courts are completely backed up. When I first started doing probate, we would have, you'd say a month, maybe 5 weeks before you'd have an executor named. I don't do probate anymore, but the individuals that I refer matters to say it's about 12 weeks to be named as the administrator. So let's say that you have a house that you want to sell. Well, that house, you can't list it, you can't sell it at all until, at the very least, you have that individual named as the executor or administrator in the case there's not a will. So there's 3 months delay right there. Then you, as real estate agent, there's all the delays and different issues that go with selling real estate. You can't do any of that in the midst midst of a probate unless you have a named administrator and the will allows you to do so. Kind of different rules with a trust. The trustee, on behalf of the trust, owns the real estate. If you're the trustee of your trust, you pass, you've named a new trustee, that trustee can keep the process going.
All right, we've said a lot of legal stuff already in this, so just to kind of break it down a little bit, this is not just for folks who have a lot of assets. This is really to be kind to the people who have to take care of matters after you've passed, right? It streamlines the process, and it gives them clear indication as to what your wishes are instead of everybody else trying to figure it out after the fact.
Yeah, I think that when you do a comprehensive estate plan that has a revocable trust, it's a selfless act because you have basically paid for some very expensive paper, and you likely will never see the benefit of it. But then your family doesn't have to go through that whole long-winded process that I talked about. Your passing is going to be hard enough. You should mourn, not be buried in paperwork and try to figure out what do I do next. And an average probate cost, I've been told by the folks that now handle my referrals, it's $10,000. Wow. Which is about 5 times the cost of an estate plan, which can avoid most of that.
Right.
So it really is something that you do for your loved ones.
Yeah.
And trusts are very intricate. They can be as simple as I leave everything to my 2 kids. If, heaven forbid, my kids pass before me, I leave things to their kids. Or you can have special needs provisions. I've had clients that have people with physical and mental disabilities, and they're on different income programs from the state or federal, and be a recipient of, be a beneficiary of a trust would disqualify them from getting those benefits. There are ways around that, but kind of what you had said is who needs this? Everyone, for the most part, unless you are fixed income in an apartment, you've already had a spouse pass, and you have one child, and that child is also on your bank account, you don't need a trust. Everything is already all wrapped up. However, there's like 4 big criteria that almost everyone fits into. Have a house, have a spouse, you have children, or you have investments. And pretty much all of us at some point or another will fall into that category.
Yeah. So when should folks start thinking about this estate planning process? Like, obviously, we know the point in which it's too late.
Right.
But how soon should they be having this conversation and engage someone like yourself?
I think people should do it like when I first started this, just had my daughter. Yeah. And so I really needed a vehicle that she could be financially taken care of if I died. Yeah. At the time, I was the primary breadwinner in the family, and we had a brand new baby. If I died, there wasn't these great savings. There wasn't any way to support them should I perish. So I had a lot of life insurance, and so I wanted that life insurance to be there for my daughter into the future. And so, but how do you keep doing that if you're gone? So I had the trust set up, and the trust was the beneficiary of the life insurance. So I would say if you get into the point of having a family, or you start even to appreciate any assets, even in your 20s, do it then. And it's something that is 100% amendable. You do a trust because you bought your first house, you're 25 years old, you're doing great, you've got a good job, you want to decide where your things go when you pass. You get married, you can then amend your trust. You have children, you can amend your trust. Very good things happen in life, very bad things happen in life, you can amend your trust. So everyone should be doing it when they're young. I think I was 31 or so when I did my first one. Of course I can do my own. But when you have things that you care about, where they go if you were to pass, or if you have people that you, more importantly, that you care about, that's the time to start thinking about at least the most basic estate planning.
Right. And I know that some folks are probably laughing at you because you said if you buy your house at 25.
Right.
Yay for those of you who have bought a house at 25. But I think the important thing is it's easier if you have a trust set up, as you start to acquire things, it just becomes habit to just put them in the name of the trust.
Right.
And we joke in our house, because you did do a trust for us, when our kids ask for something, we're like, we don't own it. Ask the trustee, which is one of the siblings. So that's always a fun thing to have a discussion about at the kitchen table. But it's easier to put things in the name of the trust as you acquire them throughout life, as
Right.
opposed to going back. You gave us a lot of homework when you set up ours to put everything in our trust.
Right.
And yeah, it's a lot of work. So.
And it doesn't have, I like to think that it's an afternoon of errands. So one of the big things that, no matter everything that you're going to forget that I say, a trust is far more important than you think. It is far easier to create and to maintain than you think. And it is one of those things that if you miss the opportunity to do it, because you pass, you get some mental incapacity, it's too late to do it. I just had and here's real two big things. One's an example. You had mentioned sometimes it's too late. I have a elderly couple. The husband is in hospice, so he's going to pass soon. The wife is, she has some kind of dementia. So she no longer has the mental ability, contractual ability, mental capacity to do anything.
Right.
On her own. The husband, he's not long for this world, so he doesn't have the ability to do anything. They miss that, and there's no more bite at the apple to get that kind of situation done.
Right.
Frankly, the only way to really take care of them is when he passes, if they have children, for them to become her guardian, which is another court process to do.
Yeah.
The reason that you do at least your basic estate planning is because the state has written a will for you, which is called intestacy. And if you might not like that will that's written for you. So if I had an estate plan, if I didn't have an estate plan and I died, it would say that everything goes to my daughter. Mm-hmm. However, maybe you have a spouse, you have a later in life spouse. They've said that the first $250,000 goes to the spouse, and then the rest is split 50% between the spouse, 50% between the children. You have all these, and that might not be the way you want it to go. Mm-hmm. So you get to be the boss, and you get to make these decisions. Yeah. Even if you do your base will, you get to say who gets what.
Right.
And that's why it's you only get a few bites at the apple in life, and life is incredibly short and uncertain.
Yeah.
So I recommend that people do it young. My favorite thing is I have people who are, I have some older clients, so they're 80 years old. And I'm getting older, so I think it's about time I start thinking about a trust. And I'm like, well, yeah, give or take 50 years.
Right.
I joke with them. So it's one of those things that if you're a college student, you don't need it. If you're living in your parents' basement, you don't need it. If you are finally out into life, you have someone you care about and things you care about, it's time to think about it.
I love that. Okay, so we mentioned probate a number of times, and just for clarification, that is the process, like after you pass, everybody, aside from the folks who have trusts, right? Which, because you will not be owning your belongings at that point, the trust owns them, so that lives beyond you. But if you don't have a trust, it doesn't matter whether you have a will or not, you go to probate.
You'll go to probate.
Yeah.
And if you have a will, I even had someone say this to me yesterday. They said, but I have a will, so I don't need to go to probate. No, a will means exactly that. I mean, at least you've made your choices. Things are going to get where you want them to be.
Right.
However, by its very nature of having a will, you will need to go through the court probate process.
Right.
And probate is not necessarily a four-letter word like I make it sound, but it just is unnecessary for so many of us, when with a small amount of planning, a couple visits to your attorney, and some of us are very friendly and approachable, and not great expense, that's over. You've taken care of everything. Right. And a trust is easy to maintain. You buy a new car, you buy it in the name of the trust. You buy a new house, you buy it in the name of the trust.
Where is some of the pushback going to come? As I experienced when we set up our trust and we were going through to, put the vehicles' names in the trust and all of that fun stuff, there was some pushback as far as if they were able to do that. And our
Right.
life insurance policies and like just the insurance policies in general, like being in the name of the trust. What advice do you have when people are getting that pushback?
Yeah, so the times that you'll see things that you cannot put into your trust, for example, if you own a car and it's financed. So your title is held by Chase Manhattan somewhere across the country, you have no idea where. You won't be able to have access to that title, to take it to town hall, to put it in your trust. When it's paid for, get right over to town hall with your trust and the title, and you get that name. Some banks inexplicably have, at least in my opinion, have some pushback.
Yeah.
You'll go into your local branch and say, hi, I have a revocable trust. I would like to change the owner, the name on my account to the name of the trust. Some credit unions, not besmudging them, but they kind of have different rules, will say, no, you have to open up a new account. If you have a bank account, you have things coming in, things going out, so it's hassly, and you don't want to have to do that. So sometimes you get some pushback. Sometimes banks will say, well, don't put the bank account in the name of the trust. Have the trust be the beneficiary of that bank account. That's not necessarily a bad thing, but I recommend you have at least one of those accounts in the name of the trust, because when you do pass, you need a place for that money to go.
Right.
So you need to have at least one. I don't know some of the logic to these. I think it's best practice, in my opinion, to have these accounts in the name of the trust. And some other, hopefully you wouldn't have pushback. Let's say you have an IRA. You come see me, you do a revocable trust. That IRA is never going to be in the trust, which is fine. Because IRAs, life insurance, other investments, you have beneficiary provisions. So you get to name in this private contract between you and the life insurance company, between you and Fidelity or whomever you have your money with. It says, upon my death, you fill out an application, give a death certificate, the money goes where you say. And sometimes, depending on how adept they are with these things, they'd understand that you have a trust as a beneficiary.
Right.
So some people bump into that, and so I get a harried call from someone sitting with their financial advisor, and we talk it through, and then once we just remind people what the trust is and what it's not, everyone gets to where they need to go.
Awesome. And so that speaks to just being curious, right, about the process.
Right.
What is holding them back from allowing it to go into the trust, understanding, kind of the parameters that they have to work in,
Right.
and then go from there.
And when you leave your attorney's office, and this doesn't happen with every estate planner, and I'm not at all professing to be end-all be-all, but it doesn't matter if you are the greatest brain surgeon ever or you're the assistant to a ditch digger. You need to know what to do when you leave, or else, like I mentioned, it's expensive paper that you leave with.
Yeah.
And so I personally try to make what I call the afternoon of errands, the bit of homework that you have to do afterwards, simple. So every single solitary person who leaves me knows what they have to do. And that doesn't happen with everyone. And folks don't like to ask questions.
Yeah.
And that's one of the hardest things is ask questions. Make me answer something that I haven't had to answer in 5 years. Make me uncomfortable, because if you haven't read the documents, if you don't understand how they work, if you don't ask me the questions, the broad strokes that I tell you how it works, you just don't do anything when you leave.
Right. And then then that's not helpful.
And then they pass, and then they still have to do an extensive probate.
Right. Oh. Okay. So trusts, you avoid probate. If you have a will but no trust, you still go to probate.
Correct.
Takes a little bit longer for your wishes to be granted.
Yes.
If you do not have a will and you don't have heirs. Oh, well, actually, let's start with the you don't have a will piece, because you mentioned that the state has a plan for what happens.
Yeah. And it's called intestacy. And so if I get some of this wrong, forgive me, but the general framework is that if you were to pass, you've got the spouse and your child. But when you think about it, and this is a complexity that I never thought about till I taught a class on this, you're just as related to your parents as you are to your children. I mean, you think if you buy, everything goes to your children. Well, you're just as related to your parents. So that's why, again, these estate plans are very, very important. But the predisposition, there's a split between spouse and children. If you have neither spouse nor children, things would go to your parents. If you don't have parents, it goes to brothers and sisters. If you don't have brothers and sisters, I believe it's then next aunts and uncles. If not aunts and uncles, then cousins, and they'll find someone. I mean, it is a possibility they will find no one. And in that case, the money might escheat to the state.
Right.
But most of us are related to someone.
Yeah.
And so they will, that's not where you want it to go.
Right.
People say, I don't care, I'm dead. You do care. You know, you have that spouse, you have those children.
If you have folks in your family that you wouldn't invite over for Thanksgiving dinner, you care.
Exactly. So, and so there is the ultimate backstop, but I don't think any of us are like, I really want less control in my life. I want to not have any say where anything happens, or when something happens where anything goes.
Yeah.
So the state and the law has contemplated that, but I gave a good example of even a child where you might not want that child to inherit. Again, I mentioned if someone's incarcerated, if they have some kind of mental incapacity that would disqualify them from getting governmental benefits. So that $20,000 now is great, but then they've lost benefits for the next 3 years,
Right.
which that's how they pay their rent, that's how they get their food, and you want to avoid that at all costs. And I had one very dear client. She had 3 children. She had a son who lived out west who was doing fantastic. And then she had 2 daughters locally, one of which had a slight mental incapacity, and then the other daughter took care of her. So she completely cut out her son, and he was very much on board with that. I don't need the money, Mom.
Yeah.
I'm doing great. You worked hard. Absolutely everything should go to my sisters.
Yeah.
And that's a choice that you would not have been able to make if you didn't have an estate plan. Even a will would do that, but your irrevocable trust.
Yeah.
To avoid probate, you get to name who inherits, who's the beneficiary, and who's not.
Right.
Not every family is completely functional.
Oh, right, and even less functional if you don't leave your stuff in a trust or have a will,
Right.
Because then everybody has to fight about it. You're trying to pay taxes, and you can't pay taxes because everything's caught up in probate,
Right.
and you also don't know where it's going to go, and everybody just gets heated, and it's not good for family units to
No.
manage that.
And it's hard. I have people who come in, and so ego really, really matters. Like, I've got 2 kids. Can I just have them as co-trustees together? You absolutely can. I also absolutely do not recommend that you do that. Well, I want someone to be my power of attorney, but I want someone else to be my executor and my successor trustee. And I think they'll work fine together. Do kids ever fight?
Yeah.
Has every Thanksgiving been perfect? And so I kind of recommend a hierarchy.
Yeah.
But then someone said, well, but Johnny's going to be upset. Like, that's Johnny's problem. You need to do the best things for yourselves
Yeah.
and for your family. Because sometimes your trust comes into play during your life. You said you've got a revocable trust. If you were to become incapacitated, hopefully all your assets are in the trust, but you're incapacitated, you need those bank accounts. You might need to sell the house. You might need to get an equity loan. You might need to do something to take your care, your health care. So you've named a new successor trustee who can do all those things.
Yeah.
So we talk about it being a testamentary instrument to avoid probate, again. But it's also during your life. You've made those plans for when you pass, but you might need to use some of those plans during your life. And that's, a will only goes into effect when you pass.
And as you mentioned before, things can come and go in the trust
Right.
as well. So it's not a means of putting things in there and then they're trapped in there and you can't do anything with it, like putting something in conservation. So you can sell the property that's in there. You can sell
Right.
the cars. You can use the money. And if you are the trustee of your own trust, which you can be, then it's once you do the work to get everything into the trust, it's just business as usual.
Yeah, no one will like this, but a trust does exist, and you have created something, but it is not anywhere, and it's not necessarily even recorded any place. It only exists on that paper, on that bank account, on that investment, on the deed to your house. So it's something that's not overly public to everyone. And I call it a legal fiction. It does exist legally, and people not going to like that I said that, but it doesn't change your life, exactly like you said. I talk about a trust being a boat. So you hired me to build a boat. You own the boat, and you're captain of the ship. You put your stuff in the boat, you sail wherever you want. Your life doesn't change. You don't like the stuff that's in the boat, you throw it overboard. You want new stuff, you throw it in the boat. You're the captain of that ship. Someday you're going to fall overboard. And so you've named a new captain of that ship. They can't sail wherever they want. They have to go to that final port of call, exactly where you said, this is what you will do as trustee of the trust. So you've already set up who will be in charge of your affairs afterwards. You have the assets that are in the trust, and so they have to follow those wishes. If they don't, a successor trustee any trustee is considered to be a fiduciary. Means that you're in charge of someone else's money. And as a result, if you have any malfeasance where you take the money, you misappropriate the money, any recklessness, any gross, any negligence, you could be financially, civilly, or criminally liable. And all the beneficiaries in at least my trust, there's a right to an accounting. So if you're the successor trustee and I'm the beneficiary, I can say, dear Sarah, show me the books.
Yeah.
And you have to.
Yep.
And if you don't, I can compel it in court that you do. So there's checks and balances on these things. As I mentioned, it's something that no one knows about except really in the trust itself, for the few people that are aware of it.
Right.
But there's checks and balances that can be done through the court to make sure people do what they're supposed to do.
And I want to highlight when you said that the trustee is the person that is distributing all of these things, right? They're the backup captain of the ship, and they're fully aware. They have to sign on that this is a job that they're willing to take on, and they understand the responsibilities of it.
You'd be surprised how many people don't know, because we have people who are very closed about it, and they're like, oh, my kids will find out about this when I die. Like, they're not going to be happy about it. You're not doing anyone any favors when you make them a successor trustee.
Right.
You're like, I have a ton of work for you to do. Sorry. However, it's absolutely essential, because one more thing about the trust. When you look at the trust, there's a whole bunch of rules that the trustee has to follow. If it's your trust and you're the trustee, it is business as usual. But someday, you're not going to be the trustee of your trust because you're going to die.
Right.
And so those are the rules really set up for the successor. And you're supposed to follow them, but you're the grantor, you're the trustee, you're in charge of your ship. But someone else has to follow the rules when it's their turn.
And I find in the real estate space, when I'm working with trustees, as well as powers of attorney or executors, they all are very similar in their jobs, but they're called different things for different reasons.
Right.
Is that they don't want to mess up. They are very cautious about the decisions that they're making, and if it's in the best interest of the trust or the beneficiaries.
Even if it's not the best interest, someone's looking for a check.
Yeah.
When we're talking about the real estate world, that successor trustee, and if it's in our world, I'm a real estate lawyer and I own a title company. I do closings. Sarah's a real estate agent who will, help a buyer who might be buying from a trust or a seller who's in a trust. There's a beneficiary waiting for a check, and so they want to do their best. They also know that they've got lots of eyes.
There's a little pressure.
Looking at them.
Yeah.
And you mentioned a couple terms. I just want to, because it is a lot of gobbledygook. A trustee only corresponds to a trust.
Yes.
So if you have a trust, the individual in charge, the captain of the ship, is a trustee. When the word executor, I try not to use them. That's in case you have to use your will.
Right.
And you have the executor of the estate, who's named in the will, blessed by the probate court, appointed by the probate court.
Yeah.
So those are just what those terms are.
And then also, if you don't have a will and you go through probate, you have an administrator.
Yeah, absolutely. It's a different term.
It's a different term, but similar function.
Absolutely. Yeah. So you are there's synonyms as far as I'm concerned. Once you've been appointed by the court, I mean, you're in charge of the estate.
There's a lot of pressure.
Again, not a job that you are doing anyone any favors by naming.
Yeah.
But there's a couple of, when we talk about estate planning, we've got a lot of emphasis on the trust and we talk about the will, but there's a whole myriad of instruments that you use during your life. Because when you go and you pay for an estate plan, It's not just what happens if you become incapacitated or more accurately that you die. We have all sorts of other instruments to either get items into the trust or to appoint people to take care of you and to take care of your affairs. So you don't have to have that example of this woman I mentioned who has some kind of dementia who can't make her own decisions, and you have to go to court to have someone named as a guardian.
Right.
Also think about that. She might not know that she has the incapacity. She might not agree that she has the incapacity.
Right.
And then she has this worthless son who thinks that she's losing her marbles. So, I mean, so these are awful things.
Yeah.
And that's why you can prevent these things by doing some instruments up front. One of the very first ones that I talk about, that I do with folks, is a power of attorney. I call it a power of attorney for finances, because that's really what is contemplated in the document. It's also called a durable power of attorney. Durable means that it survives your incapacity. So should you misplace those marbles, your lack of capacity doesn't mean that the document goes away. So, and they can be very, very broad powers of attorney. They can exist from the moment you sign them. They can only exist once you give permission for your attorney to release them. I have a few of those. Or it could be a springing power of attorney. Like, you have all this authority, but only if I'm incapacitated. And so that means that you have a doctor's note, for lack of a better term, that says, we've enacted the power of attorney because Mark has dementia.
Right.
So, and it's incredibly important because there are some assets, and this is the big thing, that if you've been a client of mine, you've heard me go on about this, there are some assets that may never be in the trust. And there's lots of parts of this world, they don't care that you have a trust. So your paychecks, they pay Sarah. They don't pay Sarah's trust. Lawsuits by you, lawsuits against you, any governmental benefits, so your Social Security, Medicare, Medicaid, your health insurance, they insure or they deal with Sarah. And so let's say that you have investments that you did long before you did your trust, so it'll always just be in Sarah's name. They're going to get what you want because you have the beneficiary provision. Something happens to Sarah. So who has the legal capacity to go cash in that IRA? Because now you need some advanced health care that you couldn't afford otherwise. So that's why you've named, via your power of attorney, an attorney in fact. Everyone's just going to say, this is my power of attorney.
Yeah.
Be a legal geek for a minute. Power of attorney is the name of the instrument. The person you've given the authority to act is called your attorney in fact.
Gotcha.
So it's an incredibly important document.
Oh, absolutely. Yeah, and that was part of the package that we received from you when we set up our trust.
Right.
Which still I have lots of questions about always, and that's why you're on speed dial.
And that's the thing, is you should be able to, you're going to have questions, and you should be able to ask them without getting back on the clock. You kind of front pay for avoiding a probate and not having to deal with these things. The other one is incredibly important because we all have different lives. Is your, we call it 3 different names. I'm talking about the same instrument. Power of attorney for healthcare, advanced directive, and living will. This is all one document, largely created by statute in New Hampshire, and I actually like it for the first time that the legislature has done something wonderful. I think it's a very, very clear document. When can't tell you how many times that I would had people sign, and I would put my hand over this because I know that's not the box that they want to check, and they would have to make an election by omission, and so it was very confusing. With the power of attorney for healthcare, you have named, if you are incapacitated, who will make healthcare decisions for you, and you generally will do a backup as well. But then that's all well and good, but then you also can do some limits on the healthcare that you want. In general, you make, and you can add things to it. There's special provisions. There are some religions that don't do, no matter what, they won't do blood transfusions. So that's a very important thing to make sure it shows up in your power of attorney as a limiter for what can be done. So generally it says A or B. A says, I would like you to use all means of extending my life as long as possible with medically accepted practices. And then it does the best thing to really paint a picture of this. It says no matter what the costs, no matter what the burdens or the complications. So even if it costs everything you want, even though you are on a feeding tube, although your life is only on a respirator, which maybe someone might want. I've only had one person in 20 years elect to make that choice. And otherwise, then you've give this person to someone that you love and that you trust and that loves you and trusts you. If you're permanently unconscious, near death, terminally ill, even if you would take a DNR that your power of attorney for healthcare, your healthcare proxy would enter in for you, because that's the only way that you can pass. We to make it personal for a minute, my mom had a great estate planning lawyer, and when she got very ill, she lost mental capacity, and she was going into her some nursing care. We entered into a DNR for her because we were empowered via the power of attorney for healthcare to do that for her. And so these are the choices that you don't have if you don't do these instruments.
Right.
Legally married spouses can make these decisions for each other. You're also largely responsible for your spouse's medical bills, so it kind of get hand in hand. But if you don't have all these other limiters or enhancers of the choices that you can make.
Right. Oh, and again, it makes it so much easier on that person because you've already stated what you want to happen.
Right.
So they don't have to think about what should happen.
Right. What do you think Mom wanted? What do you think that? And so those questions are largely answered.
Yeah.
And they're very uncomfortable conversations.
Yes.
Again, you don't discuss this at the Thanksgiving dinner table.
No.
But they're going to happen to all of us.
Yeah. Yeah. I remember when we started I did my trust first with you, and then I had the conversation with my family, like my parents, and I said, hey guys, you need to do this. So that gives me and my brother direction, when you pass, what to do. And even just saying you should think about it and start having these conversations was an uncomfortable conversation. So I think, everybody is a little bit different, but I think it's definitely something that everybody should consider.
Yeah, you're going to pay an attorney to tell you that you're going to die. I mean, so right away, that's not a fun thing to go do. And so you very much accept your mortality.
Yeah.
But one of the nice things about it, and I say this, it's kind of corny. There was this infomercial at one time, and so the guy had a roast. It's like a convection oven, and he puts a roast in there. He's like, you can set it and forget it, and you can largely do that with your trust. Once you've set it up, you've had these bad thoughts, you've had this worry, you've had the uncomfortable moments, and you just did this, again, largely selfless act to take care of your family, take care of your loved ones, and you're done. You might have to change it, or you might want to change it as life goes on, but I don't haven't anyone who has left. It's like, I'm so glad I did that.
Oh, I'm glad that I did it, for sure. And I recommend everyone go through that whole process. And especially like when I'm working with like first-time home buyers, they're buying their first house, right? And they are starting a family, or maybe they have a young family. And I'm like, you should, we'll set up the contract. So if you decide to put this in a trust going forward, you'll be able to do this. And just have that conversation with an attorney.
Yeah. And there's two other things I want to mention is that you don't need to have much to have a trust. Like I said, I didn't have more than a couple nickels to put together, but I had life insurance, which is only any value to me if I were dead. But a trust was the absolute best vehicle to make sure that got where it was supposed to be. So it is really far-reaching through your life when you're older, and every day we're all closer to leaving this ethereal plane, or if we're young and starting off. You care about everything that you do, and you care about the people that you do it with. You can completely put it behind you, and as life changes, something great happens, something awful happens, it's 100% amendable and revocable.
Beautiful. Awesome. Any parting words about estate planning?
I get paid to do this, but even if it's not me, remember that folks should emphasize on mourning after your pass, and not worrying about where did Dad want this to go? Where did Mom want this to go? Oh, where's Mom and Dad bank account? Where's their stuff?
Right.
The loss of someone and is terrible, and one thing that you should not be worrying about is what did mom and dad want? Where are things supposed to go?
Right.
It takes away the fighting of the family. When they've made the choice, you're largely stuck with it, and that's not a bad thing.
Right.
So.
Yeah, it should comfort you, should that at that time when it happens and it's needed.
I've only do a few areas of practice over the past 28 years now. It's absolutely hands down my favorite.
Oh, I love that. Oh, perfect. Well, thank you for coming to chat with us about estate planning. We are going to do a part 2, a mishmash of legal questions for Attorney Lamper. So stay tuned for that. And thank you again for watching Man vs. Land. I'm Sarah Holland.
Thanks for having me here.